Good afternoon and welcome. My name is Austin Parrish. I'm the Dean and Chancellor's Professor at the University of California, Irvine School of Law. And what a tremendous privilege to be able to welcome you to the 15th Annual Supreme Court Term in Review. Just have a couple of brief remarks. First, I wanted to thank Reza Torksada and the Tork Law Firm for sponsoring this event. They have done this for many, many years, and without their support, we wouldn't be able to put on such a great event here in the Barclay Theatre. So many thanks to Reza and Tork Law for their tremendous support. I just say they support us not only financially with this particular event, but they've also been a tremendous supporter of our students over the years. This is now my third year. Yeah, why not? I'm about to start my fourth year of being privileged to be the dean of this school, and one of the things that continues to amaze me at UC Irvine compared to almost any other law school in the country is how supportive the Orange County legal community is to us, and it makes all the difference for our students, our faculty, and our school. I also wanted big thanks to Leslie Dodds and her team who did all the work behind the scenes, and a special thanks to Professor Mario Barnes, Chancellor Professor here at UC Irvine Law, who you will hear from in just a moment, who did all the hard work of putting this program together, I think for the second time. And so many thanks, Mario, for your leadership behind this. Before I step down, I just wanted to say it's just amazing to see how much the community engages with this program. I think we had 800 RSVPs with not only the people here in this room, but a number of people, hundreds of people online watching this. That's tremendous. We also have a number of VIP guests. Very pleased that Anthony Kroll, the Dean and President of New York Law School, has joined us. Very pleased that Lauren Robel, the former Executive Vice President and Provost from Indiana University, has joined us. Kelly Testi, the Executive Director of the Association of American Law Schools, planned to join us, but her plane got delayed, and so she wanted me to pass on her hellos and welcome. And our board of visitors, many of them have joined us, many of our alumni for our alumni board. This is a great community event, and it's one of the things that makes it particularly special to have these sort of events at UC Irvine. So with that, let me stop talking and turn it over to Professor Mario Barnes, who will introduce this year's panel. Thank you so much for coming this afternoon.
So, good afternoon, everyone. Welcome to our 15th annual U.S. Supreme Court Term in Review. I'm going to take moderator's privilege before I introduce you and sort of say, I'm so thrilled to be sitting here, but here feels very different this year than the last 3 years for this event. Over the last 3 years, I had numerous concerns about what was going on in the court, but it was mostly about the court decisions of a more conservative, right-leaning court that was deciding crucial issues that have become a part of a larger culture war where the issue at that time, or over those 3 years, really was the ways in which key precedents seem to be falling by the wayside or being evaluated in new ways to make them incomprehensible. So I was worried at the time about doctrinal coherence as a professor. I was worried about the legitimacy of the court, as there were claims about the decisions being as political as they were legal. I was concerned about the actual decisions like Harvard versus SFFA, which effectively ended affirmative action in higher education, Dobbs versus Jackson Women's Health, which indicated there no longer was this acceptance of a liberty protection for the right to terminate a pregnancy, and in the most recent term, the Loper-Bright versus Raimondo case, which said judges no longer were forced to respect any deference to agencies for agency actions. And so those were substantive kinds of concerns. But where I find myself now is very different from that place in terms of concerns. The cases that make up this year's term and docket, while many of them were on important issues, were not what principally commanded our attention as court watchers and constitutional scholars and theorists. Essentially, since January 20th, what we have seen is the docket, or what we sometimes refer to as the shadow docket, being overrun by a torrent of cases that are emanating out of responses to the administration's new policy agenda, a policy agenda that has set in its targets an attack on birthright citizenship under the 14th Amendment, the deportation of folks with minimal or no due process, the remaking of the civil service through destruction, and summary removal of agency commissioners and other personnel thought to have been possibly protected from such by statutes. And so these things now have become the things that we are talking about and have become the impetus for concerns about not only the individual holdings in those cases, but respect for the rule of law and whether, in fact, we might be on the precipice of a constitutional crisis, one where we have what people have referred to as a potentially unitary executive not feeling at all bound to delimiting opinions of federal courts. And so these will be part of the things I hope we will discuss today, in addition to some of the term's most interesting cases. So I'll now start off by introducing our amazing panel this afternoon. First, immediately to my left, we have Mark Joseph Stern, a senior writer covering courts and law for Slate magazine, also the author of American Justice 2019, The Robert Courts Arrives. Do you know when they're leaving? Just asking. You seem to have the inside information. Jessica Clarke, a friend for many years, and the Robert C. and Nanette T. Packard Professor of Law at the USC Gould School of Law, who is an expert on anti-discrimination law, focusing on sex, gender, and sexuality, among other things. My friend, former dean, the founding dean of UCI, not infrequent co-author, dean of my alma mater, and Jesse Chopra professor at UC Berkeley, a leading constitutional scholar and practitioner, and author of another book. I feel like I have to say that every year, Erwin. Author of another new book, this book being No Democracy Lasts Forever, How the Constitution Threatens the United States. And then finally, I have my dear friend and colleague and co-chancellor's professor, Courtney Cahill, who is also an expert in constitutional and anti-discrimination law, who's working on a new forthcoming Oxford Press book for 2026, Busted: The Policing of Women on Top. So I'm so thrilled that you all are with me for what I hope will be not only an informative but arousing conversation about all that is going on in this moment. But we will start with you, Erwin, and what people refer to generally as the birthright citizenship case, but also Trump versus Casa.
Thank you. It's so wonderful to be here and great to be back home at UCI.
Woo-hoo!
Thank you. I want to just quickly put this in a context. Every summer, I write a book for the American Bar Association that describes the just completed term. And I try to come up with a title that reflects a theme for the year. My title for this year is Taking Sides. Our country is more ideologically divided than it's been at any time since Reconstruction. There were so many cases this term that presented issues from the culture wars. There were challenges to President Trump's unconstitutional actions. The Supreme Court consistently took sides, coming down on the conservative side with regard to the culture wars, coming down on President Trump's side. And so I believe that the most important question as we think about the Supreme Court is, at a time when our country is so ideologically divided, what does it mean to have a court that's come down so solidly and consistently on the conservative side? And I think it's in that context that I can talk about Trump versus Casa that came down on June 27th. On January 20th, President Trump issued an executive order to try to eliminate birthright citizenship in the United States. A bit of context here, too. From 1787, when the Constitution was written, it was always understood that everyone born in the United States was a United States citizen. Tragically, in 1857, in Dred Scott versus Sanford, the Supreme Court said that enslaved individuals are not citizens, even if born in the United States. They're just property. When the 14th Amendment was adopted in 1868, the first sentence was to overcome Dred Scott versus Sanford and to overrule it. It says, all persons born or naturalized in the United States with the jurisdiction thereof are citizens of the United States. In 1898, in United States versus Wong Kim Ark, the Supreme Court said everyone born in this country is a United States citizen, regardless of the immigration status of their parents. The court said, within the jurisdiction thereof just means if there's an invading army and the soldiers had children, or there's a foreign diplomat as a child, they're not citizens of the United States. No one had ever questioned that everyone born in the United States is a United States citizen. Until on January 20th, President Trump, by executive order, said only those who are born to United States citizens or those with green cards are United States citizens. 3 federal district courts clearly and quickly declared this unconstitutional. Each issued a nationwide injunction. The Federal Court of Appeals in each area upheld this. The Trump administration did not ask for Supreme Court review of those orders. Instead, the Solicitor General filed a petition asking for what it called, and I'm quoting, a modest request. It just wanted the Supreme Court to hold that nationwide injunctions are impermissible. The Supreme Court scheduled oral argument for Thursday, May 15th, and on Friday, June 27th, the Supreme Court, in a 6-3 decision, essentially ended the ability of federal courts to issue nationwide injunctions. Justice Amy Coney Barrett wrote for the court. Justice Thomas Alito and Kavanaugh wrote concurring opinions. Justices Sotomayor and Jackson wrote dissenting opinions. There is blistering dissents, as you'll find anywhere in the United States reports. Justice Kagan also dissented. It's interesting that Justice Barrett's majority opinion focused on the statutes creating federal courts. It wasn't a constitutional ruling. And she said, in order to understand whether federal courts can issue nationwide injunctions, we need to look to whether or not chancery courts in England could issue such injunctions. Justice Jackson responded to this by saying, in England, the courts couldn't stop what the king was doing. We shouldn't be looking to what English courts could do in the 18th century to decide what courts can do today. Justice Barrett said that nationwide injunctions are relatively new. She said the first one she could identify was in 1963. And she said, we're not going to pay attention to the context. We're just looking at the power of the courts. Justices Thomas and Alito wrote concurring opinions to say, let's not see things like nationwide class actions and suits by states take the place of nationwide injunctions. Justice Kavanaugh wrote an interesting concurring opinion saying, you know, just bring everything to the Supreme Court on its shadow docket. He literally said, we're open 7 days a week, 24 hours a day. Come to us. Justices Sotomayor and Jackson both saw this as a real threat to the rule of law. Justice Sotomayor said there have been nationwide injunctions at least since the early 20th century. She expressed concern that if there's not a nationwide injunction, then would you need to file a lawsuit in all 94 federal districts to stop a practice? She expressed real concern that a president could do something unconstitutional and just wait until each district struck it down, continuing the practice was not restrained. She talked about the practical consequences. So does this mean that 2 babies born under identical circumstances in 2 districts could have one a citizen and one not? And Justice Jackson said, once a court declares something unconstitutional, it should be unconstitutional. So how should we think about the case? To some extent, its importance is going to depend on whether or not nationwide class actions and suits by state governments can achieve the same goal as the nationwide injunctions. Obviously, some justices think so, but Justice Thomas and Alito very much said, don't allow these to substitute for nationwide injunctions. If they don't substitute for nationwide injunctions, then do we really get to a situation where there has to be a lawsuit in every federal district in order to stop a presidential practice or an unconstitutional federal law? And ultimately, I conclude with what both Justices Sotomayor and Jackson emphasized. At a time when we have a president who's repeatedly pushing the bounds of the Constitution, in all the ways Mario suggested, what does it mean to have a court that's lessened the ability of the courts to check the president? At this moment in time, our guardrail of democracy is the judiciary. What's it going to mean to have the court so weaken the powers of the judiciary to stop the president and enforce the Constitution?
So thank you, Erwin. I will note that Justice Coney Barrett responded quite viscerally to what Justice Brown Jackson referred to as the existential threat to the rule of law by noting that she wanted to replace what she saw as the imperial executive with the embrace of an imperial judiciary. So is that what Sotomayor and Jackson are essentially offering us in place of what they're concerned with as the overreaching executive?
I think what's interesting is that Justice Barrett's majority opinion says we're not going to look at context, whether or not we need nationwide injunctions to stop the president. We're just going to look at history. Is this a power that courts had in the late 18th century? Was what Justice Souter and Jackson want to talk about is we have to look at context here, and we can't ignore this is about lessening the power of the court at a time we have a president violating the Constitution. I do think that Justice Barrett's response to Justice Jackson crossed a line. She basically said, I'm not going to deign to talk about what Justice Jackson has raised here. I think that there's been an increase in sarcasm and put-downs among the justices, and it's lamentable whether it's conservatives or liberals doing it, but I think that Justice Barrett treating Justice Jackson that way was regrettable.
Mark, you have thoughts?
I just wanted to add to that. I think that Justice Barrett's extraordinarily disrespectful response to Justice Jackson may well reveal some biases on the part of Justice Barrett about what kind of people are allowed to have opinions on matters of law. It seemed that Justice Barrett simply did not respect Justice Jackson's extraordinarily forceful and intellectual rejoinder, and yet Justice Barrett, when she disagrees with, say, a white male member of the court, somehow finds a way to afford a lot more respect. And I think that the bad blood that we're seeing emerge between those two justices may go deeper than just surface-level substantive disputes over the law, and that the contempt that Justice Barrett showed toward Justice Jackson was quickly picked up upon in the conservative media, in the press, in the political sphere. There has been a pile-on Justice Jackson, accusing her of being a mediocrity, accusing her of being an affirmative action hire, all of which is fueled by Justice Barrett's response, and I think that she owed her colleague much more consideration than to lob a dig that was quickly picked up upon by racist, sexist forces to encourage a misogynistic and racist view of Justice Jackson's intellect.
Well, I think one of the more outrageous claims I've read in the last few days is how dare Justice Brown Jackson have the audacity to write a solo dissent, given her newness to the court, almost so that she should sit in deference and learn something by being on the court before she deigned to voice any opinions for which there are no others who join her, which I find I've never heard that before. I mean, I've never heard it suggested that you're not immediately qualified to speak on the matter.
Would you say there's maybe a double standard?
I would not say that because I cannot absolutely prove it, but it certainly seems to be a problematic complaint. So I'll turn to you now and ask you, before we talked about the Planned Parenthood case, to give your general impressions on the term this year, and then to speak more specifically about Planned Parenthood versus Medina.
So, I think when Trump came back into office on January 20th, the big question was whether the Supreme Court would function as a significant, meaningful restraint on his power. And I think nearly 6 months in, we can safely say that the answer is no. The Supreme Court instead seems to largely share Donald Trump's expansive vision of executive power. The Supreme Court does not seem to mind most of what I would consider to be Donald Trump's abuses of office. And in fact, the Supreme Court is much more concerned about lower court judges who are trying to stop Trump from enacting the most extreme elements of his agenda. And I think that CASA is a perfect example of this, because in that case, you had sort of two potential emergencies. One emergency is the fact that the president, for the first time since the 14th Amendment was enacted, is trying to overturn birthright citizenship. But the other potential emergency is that 3 district courts are trying to stop the president from enacting an obviously unconstitutional policy. And so the Supreme Court had an opportunity, right? It had a choice. It could have said, wait, this goes way too far. We need to reach the merits and stop this policy immediately. Or it could have said, you know who's really out of bounds here is these district court judges. And it picked the latter option, and it decided to smack down those district court judges instead. And Justice Jackson, in her dissent, described the majority as fostering a culture of disrespect toward those district court judges. And I think that's exactly right, and I think that's what we're seeing. The Supreme Court will tap the brakes from time to time in the Alien Enemies Act cases that I think we might talk about. But in those circumstances even, it seems that the court, the conservative supermajority, is more concerned about preserving its own power, about reminding Trump that it still sits at the apex and that it gets to tell him to stop when it wants to. But even
will they ever want to?
They rarely do.
Okay.
They very rarely do because they share the same agenda. And I think that sort of segues into the Planned Parenthood case, if I can sort of move into that. I mean, so this is a case that's another perfect example of what Erwin described, of the majority taking sides in the culture war, right? This is a case that is not about abortion, but is also entirely about abortion. It involved South Carolina's effort to defund the 2 Planned Parenthood clinics in the states. The issue here did not directly attach to abortion because Medicaid dollars do not cover abortions under federal law. As a rule, Medicaid cannot cover abortion services. So when South Carolina said, we want to cut Planned Parenthood out of our Medicaid program, we want to defund it, it was not saying we want to stop the Medicaid funding of abortion, because that wasn't happening. What South Carolina was trying to do was stop Medicaid reimbursements for other services, like STI screenings, STI treatments, cancer screenings, well-woman checks, a variety of services that should be uncontroversial, that are not directly related to abortion. South Carolina, the Republican governor, wanted to defund all of those treatments because he was mad that Planned Parenthood happens to also provide abortion. So after he did this, a patient sued, along with Planned Parenthood, and they said, wait a minute, you don't get to tell Medicaid patients where they can get services. And that comes straight from the Medicaid statute that Congress enacted, which has a provision that's called the Free Choice of Provider section, which says, in terms so clear that a preschooler could understand them, that if you are a Medicaid recipient, and we will talk soon about how some of these justices do not seem to have the reading comprehension of a preschooler, and this is one example. It says, in clear as day language, if you are a Medicaid recipient, you get to choose your provider. You get to go to a qualified provider, and that provider will be reimbursed for the services that they give you. No one argues that South Carolina's Planned Parenthood clinics aren't qualified to provide all of these other non-abortion services. Everyone agrees that they're qualified to provide those services. So the question in the case was, okay, so can this individual still access those services, or does South Carolina get to cut them off? And the Supreme Court said that South Carolina got to cut them off. The Supreme Court, in fact, said that a Medicaid patient doesn't have a right to vindicate the choice that Congress expressly gave to her in the statute to choose her own provider, because Congress didn't grant that choice in language that was clear enough to satisfy 6 Supreme Court justices. What the court said was, Medicaid is spending clause legislation. It is Congress giving states money to spend in a certain way. And when there is a law of this kind that creates rights, it has to use certain magic words. It has to use the word right over and over again. It has to be crystal clear, even clearer than Congress was in this case, that it is giving a patient a specific right, or any recipient of any service or federal welfare program, a specific right to go to court and sue if they are denied that right. And the supermajority said in this case, that right doesn't exist. Congress wasn't clear enough. But it was clear enough. It gave patients the right to choose their provider. And so the question is, why did the Supreme Court say that it wasn't clear? Why did the Supreme Court say that patients don't have a right? I mean, first of all, I want to say that the consequences of this decision are really, really devastating. It goes beyond Planned Parenthood. It covers much of Medicaid. Because from here on out, if you are denied services under Medicaid, or Medicare. If your state or even the federal government tries to cut off reimbursements for Medicare or Medicaid services, you no longer get to go to court and say, wait a minute, I was guaranteed this by Congress. The Supreme Court has taken that away from you. And that goes for a bunch of other spending clause legislation, including education funding, disability funding, all kinds of services. After the Supreme Court decision, you can't sue to vindicate your rights anymore, which seems like a huge problem. And so the Supreme Court only got here by essentially gutting Congress's ability in the first instance to create rights that individual citizens can vindicate. And I think that that shows an ongoing agenda by the conservative justices to say that even if you have rights on paper, you have no way to vindicate them. And we see that in a lot of different contexts of constitutional rights as well. But I think this is another instance of the Supreme Court's conservatives saying, even if Congress tried to give you this right, even if Congress went out of its way to ensure that you could access some service or benefit or whatever, we are going to take that away from you because we don't think Congress should be in the business of creating rights. We're the only ones who get to do that.
Wow. You seem to have a very strong opinion. But and much of it, which I agree, especially in terms of the sort of now ethereal nature of statutorily created rights.
They don't exist anymore.
Right. But I do want to get into a conversation that perks up between Justice Thomas and Justice Brown Jackson in this case, because they start going back and forth over the originalist perspective used to interpret Section 1983.
Yes, that's right.
Which is a civil rights provision which, in theory, gives you a right to sue for violation.
Which has now been gutted.
Yes. So my sense is she does something that many people think you can't do, which is propose a different theory of originalism, one that might offer a reliance on different histories or different perspectives of what was going on at the time, including for Section 1983. Thomas says, well, look, if you look back then, there weren't very many people using Section 1983 to sue, and she basically says because it was the period of Jim Crow, and there would be devastating consequences to the progeny of freed slaves trying to come forth and exercise right through this means. And so she's trying to complicate or even provide a more sophisticated analysis of the historical moment. But we discussed this at dinner. Is it a worthwhile project to suggest that originalism, in fact, can be useful in this way, rather than to argue that there are just severe limits to allowing ourselves to be governed by what the framers thought at the time?
I think it is always worthwhile to point out that Justice Thomas is a terrible historian who has no understanding of the actual professional historical practice of interpreting historical records and texts and evidence. He has the most simplistic, biased, cherry-picking approach to history that you could envision. It is hard to use rhetoric that would fully capture how poor he is at understanding what happened in the past and applying it to current events, which seems to be a problem because that is his entire jurisprudence, and he is terrible at it. So I think that Justice Jackson was right to go after him. And just to sort of recap what you said, so, again, the Supreme Court sort of gutted the creation of rights by Congress. There's a statute, Section 1983, that was enacted after the Civil War that expressly gives people the ability to go into court and vindicate their rights. And what Justice Thomas says, and by the way, I will say this is wrong, but it's a more coherent theory than the majority can even muster. And Justice Thomas says, well, receiving welfare isn't even a right at all. So if you're receiving Medicaid reimbursements and you're cut off from them for no good reason, well, that wasn't a right in the first place, so you don't have the ability to vindicate it. And in order to support that proposition, he cites like 3 dead white guys from the 1870s, okay, who do not have a monopoly on the definition of the word rights, either in 1871 when the statute was enacted or today. And so, this idea that you can just go back and cherry pick a few definitions from a few dead white dudes and use that to radically overhaul the law, that is Clarence Thomas's bread and butter, and Justice Jackson isn't having it. And so she responded to Justice Thomas and said, you know what, Justice Thomas, first of all, I don't think that this is there's any way to do history, which is correct. Any professional historian at this esteemed institution, even all the way down to the lowest ranked community college in this country, would say that what Justice Thomas is doing is not legitimate historical practice, right? Not legitimate historical research or analysis. But what Justice Jackson says is, if we're going to do that, right, if we're going to actually look at the evidence and just try to find stuff that points us toward the original meaning of this text, why are we only looking at white guys? Why aren't we looking at what people of color thought the word right meant in the 1870s? Why aren't we looking to the colored conventions, which were a series of conventions put on by people of color that, among other things, debated and discussed constitutional and statutory rights? And she cites the colored conventions to show that there were at least some people of color, some very well-educated, thoughtful people of color in the 1870s, who did think that a right encompassed a benefit or a privilege or even welfare from the state. And so Justice Jackson, I think, is trying to counter Justice Thomas not by saying this isn't how you do it at all, but saying even if I play your game on your turf, you are either wrong or I can contest the conclusions that you are drawing. And I think it's very powerful and useful to have someone on the court who is able to do that and take that approach.
Wow. You can clap this time. Next year we should get people with stronger opinions on things. So I would make sure not to cut off any other comments or discussion on the case before I move on to Jessica. There was one moment when you said twice 3 dead white guys from the 1870s, and I thought, would you expect them to be living at this time? and would that make it better? But Jessica, we'd like to hear from you your sort of general impressions of this term, and then to have a conversation about U.S. versus Scrimity.
Sure. So I agree with the themes that have already been mentioned. I want to say another thing, though, about the court's use of its emergency or shadow docket. So I think this is a way that the court is arrogating more power to itself. And in most of these cases that we've seen, the court has let Trump administration policies go into effect after district court judges have said we need to put a pause on those policies to figure out if they're constitutional. So that's concerning. But there's also something that's concerning about it procedurally. So we see on the shadow docket the court making new pronouncements of the law, sometimes with very little briefing or time for full examination of the issues. So I think that's troubling. Another thing that's troubling about it is that the court often comes out with decisions with no reasoning for the public to examine or understand. There is a bright spot on the shadow docket, which is that 9 justices said that people who are going to be deported under the Alien Enemies Act are owed due process of law. That's a bright spot. But then, inexplicably, they didn't seem to think there was due process if the administration had decided to deport them and then decided to send them to a third country, like South Sudan or Libya. And we don't know quite why, although we could guess. So I think that's troubling, this use of the emergency docket. I also think another theme is the court choosing sides. So we see that in a lot of culture war issues, the court choosing religious traditionalists over the LGBTQ community, the court neutering civil rights statutes, the court giving the executive a wide berth on immigration. And another theme, I think, that comes up in the Scrimity case that I want to talk about in a second is empty formalism. So rather than admitting what it's doing, rather than acknowledging that it's making value judgments in hard cases, the court hides behind empty legalisms. So it gives us circular logic. It gives us an invented history or tradition as the excuse for what it's doing. The court contorts texts. It contorts the texts of statutes. It contorts the texts of children's storybooks. It contorts the words of the Constitution. There's a great quote from one of the shadow docket cases from Justice Ketanji Brown Jackson. She said, "Children, pets, and magicians might find pleasure in the clever use of such shiny object tactics, but a court of law should not be so easily distracted. And in that case, she was talking about the use of procedure to avoid substance. So I think this empty formalism is another important theme.
So let's talk about scrumity.
All right, so scrumity, United States versus scrumity. I want to start with where this case began. This is a case that was brought by Samantha Williams, the mother of a transgender daughter in Tennessee. In 2020, after her daughter came out as transgender, the Williams family sought evidence-based health care. There are two forms of evidence-based health care at issue in this case for transgender minors who suffer from gender dysphoria. One is called puberty blockers. So puberty blockers are drugs that are taken by children at the first signs of puberty. They're reversible. They basically put puberty on pause. So the child, the family, and the doctors have time to figure out whether to proceed on to other treatment. So for a transgender girl, puberty blockers would prevent her from going through male puberty. There's another set of drugs as well, hormones. So transgender minors sometimes take hormones. A transgender girl would take estrogen to go through female puberty. The Williams' daughter was pursuing these forms of health care, and according to her mother, she was thriving, happy, and healthy. But during the pandemic, there was a backlash that affected transgender children in red states. Red states began passing laws restricting transgender people from using restrooms consistent with their gender identities, from playing sports, from changing their identity documents, and from pursuing gender-affirming health care. In 2022, a right-wing provocateur held a rally in Nashville where he called transgender identity a delusion. He said that clinics were out to make money on transgender kids and that they were mutilating, drugging, and castrating children. And he told Tennesseans it was a fight of good against evil. In this context, Samantha Williams went to try to testify before a Tennessee legislative committee about how these drugs had improved the life of her child and the lives of other children. But she said they barely acknowledged that she was in the room. They just wouldn't listen. In 2023, Tennessee enacted a ban on puberty blockers and hormones for transgender children, and Samantha Williams, with the help of the ACLU, brought a lawsuit. The case was assigned to a judge appointed by President Trump, Judge Eli Richardson in Nashville. He was persuaded by Samantha Williams' argument. He was persuaded to put a temporary pause on the Tennessee ban so that he could figure out whether it was constitutional. And he decided that it was likely not constitutional. Under the Equal Protection Clause, courts have held that when you have a law that classifies on the basis of sex, there has got to be an exceedingly persuasive justification for that law. This is because historically, when legislatures have gone about passing laws classifying people on the basis of sex, it has not been for a good reason. So there were two questions in the case. The first one is, well, does this law classify on the basis of sex? If you look at the law, if you read it, you'll see it does right there in the first provision. What the law does is it says puberty blockers and hormones are allowed for all children, except for those who are seeking to use those drugs to live as an identity that the legislature thinks is inconsistent with the minor's sex. That is literally what it says, the minor's sex. So children who are not transgender can use these drugs. Children who are transgender may not. All right then, the second question is there an exceedingly persuasive justification for the law? Well, there wasn't, because there was evidence that these drugs improved the lives of children, like Samantha Williams' daughter. And it's true, these drugs have risks, like all drugs. But the legislature was allowing the exact same drugs for children who aren't transgender. And so it's parents and doctors who should be weighing the risks of benefits. That was the lower court decision. The Supreme Court, unfortunately for the Williams family, disagreed. The court just did not want to disturb the laws that had been enacted by more than half the states at that time, banning gender-affirming health care for transgender minors. They didn't want to require that those states show that they had persuasive justifications for the laws. Okay then, well, the Supreme Court had to figure out how the law was not a classification on the basis of sex, even though it had a classification on the basis of sex in its first provision. So what they said was, this is not a law that classifies on the basis of sex. It's a law that classifies on the basis of age and medical treatment and diagnoses of gender dysphoria.
And sex.
But wait a minute, right? So the Supreme Court had said you could have laws that classify on 11 different bases, but so long as one of them is sex, you've got to have an exceedingly persuasive justification for using sex, right? So that's one problem with it. The second problem is the law classifies on the basis of the minor's sex. A third problem with this is gender dysphoria is a diagnosis defined based on sex. Gender dysphoria is clinically significant distress that accompanies having a gender identity that's regarded as incongruent with a person's sex. But the Supreme Court will not look underneath the definition of gender dysphoria. It will not see that therein is a sex classification. So that is the holding that we have, folks. There's an upside to this. It could have been so much worse, so much worse. The Sixth Circuit Court of Appeals had a worse rule. The Sixth Circuit Court of Appeals would have said, so long as you have a law that puts equal burdens on men and women, it's not a classification on the basis of sex. So because this law doesn't allow transgender boys to use testosterone or transgender girls to use estrogen, it's not a classification on the basis of sex. Both boys and girls are equally burdened. Now, this is a terrible rule because...
That's Plessy versus Ferguson.
Separate but equal. You could say, we're going to make all the girls take home economics and all the boys take shop class, and that's equal burdens on both sexes. So that's a terrible rule. And we wrote an amicus brief arguing to the Supreme Court, please don't do that. And they didn't. They didn't endorse that rule, thank goodness. What we have instead is a limited holding, that when you have a law that singles out certain medical treatments based on gender dysphoria, it's not a classification on the basis of sex. So it could have been worse. That's a limited holding. Now that's the upside, but there's a big downside. The big downside is the Supreme Court just granted certiorari in another 2 cases on transgender rights, Hecox versus Little and BPJ versus West Virginia. And next term, they're poised to decimate what remains of transgender rights under the Constitution, as well as Title IX of the Education Act amendments.
So, and I mean this not in a facetious way, but if a statute that gives you rights doesn't give you rights, and a statute that addresses sex doesn't address sex, what are litigants and their representation supposed to do in terms of constructing good faith arguments based on plain statutory meaning to bring things to the court? I mean, I'm just suggesting these decisions seem, contorted or peculiar or bizarre. What are we supposed to do with decisions that are so far afield of what common sense or normative readings of things would produce?
I think we have to keep pushing. So we have to read these decisions narrowly, for one thing.
Okay.
We shouldn't take them to be broad pronouncements. We should take the court seriously. When the court says this decision is about a medical treatment, don't read it expansively as applying to anything else. So read them literally, read them narrowly, keep pushing, and slow their roll. And keep making the textualist arguments. And when they contort the text, point it out. That's something Justice Sotomayor did in her dissent. She said, this decision contorts the text.
Erwin, and then I'm going to hear from you more expansively, Courtney. But Erwin first.
Well, go ahead. Please.
No, because I'm going to ask her to give a segue between this case and her case. So
there was another issue in the case, and that involved how should discrimination against transgender individuals be treated under equal protection? Okay. Should it be that the government wins so long as it's reasonable, or should it be treated like sex discrimination, where there has to be an exceedingly persuasive justification, or even like race, where it has to be strict scrutiny. And interestingly, Chief Justice Roberts' opinion said, we're not going to reach the question because we don't see this law as being discrimination on the basis of gender identity. And that's hard because that's what the law is all about, is discriminating against transgender individuals. But the way he got that is worth focusing on, and I guess I have to use the word contorted here. He invoked one of the most ridiculed Supreme Court cases in history, a case called Gould versus Aiello. It's a 1974 Supreme Court case. It involved California saying for its employees it would pay disability benefits for any medical condition that led to disability, but not pregnancy when it led to disabilities. So the state would pay for disabilities that could affect only women, say ovarian cancer, or disabilities resulted that only could affect men, testicular cancer, but not pregnancy-related disabilities. And the question is, was excluding pregnancy sex discrimination? And the Supreme Court said no. The Supreme Court said there's two categories of people, pregnant persons and non-pregnant persons. Because women are in both categories, it's not sex discrimination. I have not caricatured that. That's exactly what the Supreme Court said, word for word. Chief Justice Roberts in the United States v. Committee invoked Geduldig and says, well, there's two categories of people here. There's transgender individuals who can't have these hormones for gender-affirming reasons, and there's everybody else who can have these hormones for other reasons. He said since there's transgender individuals in both categories, it's not discrimination on the basis of gender identity. We don't have to decide how it should be treated under equal protection. But I think that there's no doubt where the court's going. Justices Thomas and Alito and Barrett write strong opinions saying only rational basis review. There's another shadow docket case we haven't talked about, United States versus Schilling. It involved President Trump issuing an executive order to bar transgender individuals from serving in the military. Federal district court struck it down on equal protection. The Supreme Court 6-3 reversed that, allowing President Trump to do this. I don't think there's any doubt where the court's going on this, but it's interesting that Chief Justice Roberts wanted to hide it and not be explicit about what the court was saying with regard to gender identity discrimination.
Wow. Okay, so Courtney, I should allow you get the widest berth because you both can give your impression on this term, add anything else you'd like to about Scrimetti, and then introduce us to the Mahmoud case.
Sure. So I think just one comment to Dean Chemerinsky's point on Geduldig, this 1974 case. It was originally kind of, as you say, it was ridiculed as soon as it was as soon as it came out. This case was ridiculed in 1974, right? And the Supreme Court itself didn't really, only cited to it 17 times in its entire, 17 times between 1974 and 2022, which was Dobbs. And in most of those cases in which the court cited to Geduldig, they weren't following it. It was often cited to in dissent. And so what's interesting is that Dobbs kind of literally brought this case back to life in dicta when Alito says in Dobbs, criminal abortion bans are not sex discrimination because abortion is unique to women. It is biologically unique to women because pregnancy is biologically unique to women. See, e.g., Geduldig. And it wasn't just Geduldig, it's a footnote in Geduldig. So it's really like buried, you really got to excavate it, right? It's really buried in there. So what the court did in Dobbs is misquote Geduldig footnote. It was footnote 20 from Geduldig, and Dobbs misquotes it because the footnote itself says nothing about biological uniqueness. There's nothing about the footnote that says that. And so what's interesting in Scrimetti, the footnote is revived, but then takes on a different meaning. And I'm not even quite sure, I'm not convinced that the meaning that the chief gives it to it in Scrimetti tracks how the court used it in Geduldig. Right, because when the court in Geduldig says, oh, okay, pregnancy discrimination creates two classes, pregnant people over here and non-pregnant people over here, it then says the non-pregnant people include both men and women who get the benefits of the disability program, whereas here, trans people and cis kids are not getting any benefits, so to speak, from the state. It's a complete sort of taking it, wrenching it completely out of the context in which it occurred. So we see like this more glosses on this footnote which was really small, to make it really, really big to capture so many things, right? To kind of shut down so much of equal protection. Can I ask Jessica a question?
Sure.
Okay, so my question for you is, I'm wondering if when the majority in Skermeti says, doesn't make the move that you say, right? Since it's burdening both males and females, it's sex neutral, right? They didn't do that. But I'm wondering if you think, what do you make of the fact that they did say, the chief did say, no minor can get the gender affirming care. No minor can use puberty blockers or hormones to change, quote unquote, change their sex. Isn't that effectively doing that? Like, no minor can do it, meaning both males and females are prohibited from doing it. Right, like I wonder if by kind of conceptualizing this as a minor discrimination, it's just a shield to hide what's really going on, which is sex discrimination.
So I agree it's a shield to hide what's going on. I'm not going to attribute to it any coherence.
Right.
Nor do I think that it establishes any precedent going forward that equal burdens on men and women, boys and girls, would mean you don't have a classification that requires heightened scrutiny. And the court realizes that, and there are some hypos that the court deals with in which it's clear they realize that. So one hypo that they deal with is, well, could you ban someone from attending religious services inconsistent with their religion? And the court says, oh, obviously not. Could you ban someone from wearing clothing inconsistent with their sex? Well, obviously not. Can you ban someone from taking medicine inconsistent with their sex? Oh, wait, now the court is confused. So there is something about medicine that has confused the court. This case is limited to medicine. It's limited to what the court calls medical treatment, a term that it makes up a definition for. It says a medical treatment is both a drug and a diagnosis. And then it says if the diagnosis is gender dysphoria, that's a neutral thing. That has nothing to do with sex, folks. That has nothing to do with being trans or not trans. That's a neutral thing. We are prohibiting a medical treatment for gender dysphoria. That's not a sex classification. That doesn't discriminate against transgender people. That's all the court says.
Let me translate. Pay no attention to the man behind the curtain.
It's a shiny object,
yes.
Right? They're doing they're playing a shell game. They're hiding stuff.
Right.
Okay, so your thoughts on the term more generally, if you like, and then Mahmoud.
Sure, so my thoughts on the term. So like my fellow co-panelists here have already talked about it. They're just like, the gloves are off, right? I mean, the sort of the tenor of the exchanges between the justices seem different, not just in degree, but in kind as well, I think, from what I've seen in prior terms. So that's one thing that really stuck out at me. The other thing is, and this kind of segues into kind of between Jessica's case and my case, is the way in which some of the cases that the court decided this term conceptualized children and the relationships that children have with their parents, right? And so how do they conceptualize children? So Skermeti was a case involving children, right? Because the laws at issue banned the medical care for minors, right? So adults can still get the same things that Jessica talked about, but just that minors can't get it, right? And there were special concerns with respect to giving, administering these medicines, these things to medical procedures to children. The case that I'm going to talk about, Mahmoud, which is a case about basically like public education, public schools, and whether or not public schools sort of are indoctrinating students when they expose them to certain concepts, young minors, when they expose them to certain concepts. The class that was really at issue there were kids who were exposed to these concepts like same-sex marriage that might violate their parents' religious beliefs, were K through 5, kindergarten through 5th grade. So we're talking about children in both sets of cases. And what struck me in reading both of the cases was how the court really saw children as these unformed, completely blank slates who were susceptible to the whims of sinister adults who wanted to manipulate their minds and body, right? And it was like as if children had no ability to interpret texts, right? To interpret what texts mean, and I'll get into that in a moment, let alone any ability to determine their life's course with respect to what their body is going to look like, right? Or what body they're going to inhabit, right? So children in these decisions have no agency at all. And they have no ability to interpret. They have no ability to sort of understand certain basic human needs. So that really stuck out for me this term. So my case, Mahmoud versus Taylor, comes from Maryland. So Montgomery County, Maryland, which was one of the largest school districts in the United States, instituted, kind of changed its curriculum or introduced into its curriculum a few years ago 5 LGBTQ inclusive books. So some of these books talk about same-sex marriage. I used to read one to my kids when in the book that received a lot of attention in the case. It's called Uncle Bobby's Wedding, and it's the experience of Uncle Bobby's niece Chloe seeing her uncle get married. When I used to read it to my kids and they loved it, I thought it was mice. But Mark corrected me that it was guinea pigs. Right? So Uncle Bobby and his male partner used to be guinea pigs. Now they're humans. I didn't know that because when they reproduce, Sotomayor reproduces a lot of the book in her appendix, and I'm looking at it, I'm like, who are these people? Oh, wow, they made them human. So Mark and I were talking, I wonder if part of the problem, maybe they should have just stuck to guinea pigs. So anyway, so one of the books is Uncle Bobby's Wedding. Another book is about a child whose gender, they, them. Another book is about a trans child, sort of introducing her identity to her parents and how her family responds. Okay, so there were the 5 LGBTQ inclusive books. When Montgomery County, for K through 5, for the K through 5 curriculum, when they first introduced these books, they said to the parents in the county, in the school, if you want to opt out, kind of like sex education, if you don't want your kid to be exposed to these books, you can opt out. But you have to tell us, and we have to have a sufficient time so we know not to pull the book off the shelf and read it, right? We have to tell you, if you don't want your kid to be there when we read the book, they don't have to be there. Fine. The school quickly realized that the opt-out was unmanageable. It was unworkable. And it was unworkable first because, as we know, anyone who has been to a K through 5 classroom, a lot of the time, especially at the younger ages, it's reading hour or reading time is kind of ad hoc, right? The teacher pulls the book off the shelf and just starts reading. So you don't know in advance that you're going to be reading a book. So teachers were like, we just don't have sufficient lead time to inform the parents that their kids can have an opt-out. So that was one reason why they got rid of the opt-out. The second reason was they said, look, kids are getting the opt-out and they're leaving the story time circle when they're reading about same-sex marriage or trans or gender non-conforming kids. Well, a lot of our kids have same-sex parents. A lot of our kids are gender non-conforming. A lot of our kids are trans, right? And they're seeing their peers leave the room when they're talking about these concepts, and it's creating social isolation and stigma. So we're going to get rid of the opt-out, okay? We're rescinding the opt-out, so there's no more opt-out. So at that point, the parents then said, they complained, and they said, by not giving the opt-out, you're substantially burdening the parents' free exercise rights, our religious liberty rights to raise our children according to the religious principles that are part of our religion, right? And the things that they're being exposed to, like same-sex marriage or gender nonconformity or transgender or whatever, violate, they burden us as parents, our ability to raise our children according to the religious beliefs that we espouse. Okay, so they brought a First Amendment free exercise claim against this sort of opt-out refusal. The parents lost, the school won at the courts below. When the Supreme Court decides the case last week, I think it was the 27th, and the Supreme Court ruled for the parents. And the court in Mahmoud says, look, it is a substantial burden on parents' free exercise rights because exposing children to these concepts is tantamount to indoctrination. And that indoctrination, right, runs counter to the principles that the parents want to indoctrinate their kids with, right? So there's this sort of tension. Okay, so how did the court get there? Like, how is hearing a story about former guinea pigs getting married the same thing as indoctrination? So the court, Alito goes line by line through these books. I know the lines well. I read them to my children many times. And says, look, that's indoctrination. That's indoctrination. That's indoctrination. Well, I'll just give you one example. One example that he gives is after Bobby and his partner, his husband, get married, say, I do, everyone claps, right? Yay, everyone's shouting, yay, we're happy. And Alito says that's indoctrination because that is basically saying that same-sex marriage is a good thing. Right, what the author intended there, and he kind of, as a former literary critic, I'm really offended because he's like, clearly that's what the author meant. The author meant this is supporting same-sex marriage as an institution when everyone claps. Not, oh no, we're just happy that these two people found the love of their lives, right, and memorialize that in front of everybody. So he said that's indoctrination, right, and that exposing kids to those stories was a form of indoctrination that substantially burdened the parents' religious practice or religious beliefs, and that the state, in this case Maryland, Montgomery County, didn't have a sufficient justification, right, wasn't able to satisfy that, to justify that substantial burden. So the school loses. What does this mean moving forward? It means a lot of things. It means that sort of this expansion of religious liberty that has been happening on the court for years now just got a whole lot bigger. So it means the free exercise clause has gotten a whole lot bigger. And at the same time, it means that public education, in some very real sense, I think, has gotten a whole lot smaller as a result. Because now it's not going to be limited to these 5 LGBTQ inclusive books, right? You can imagine moving forward, it could be a lot of different subjects to which parents have religious objections that they don't want the teachers teaching the children, exposing the children to exposure as a form of indoctrination. So it's really going to shackle what educators are able to do in the classroom. Yeah.
Please.
So I have to step in as another parent who has read Uncle Bobby's Wedding 200 times at least, and who interviewed the author of the book, so I am something of an authority on this, not to brag. It is extraordinary to me that Justice Alito fundamentally misunderstands this children's book, right? And I'm not to get too deep in the weeds, but I'm going to get in the weeds. Like, the central conflict in this book is that Chloe, Bobby's niece, is worried that her special uncle will have less time to spend with her because he'll be busy with his new husband. That is the tension. And she learns that, in fact, even as families grow, there's still enough love to go around. That is the resolution. Yeah. In Justice Alito's telling, this was both during oral arguments and in his opinion, he claims that, in fact, Chloe's hesitation, her resistance to Bobby getting married, is that she doesn't think that same-sex couples should be able to get married.
Chloe's quite sophisticated.
That this little 4-year-old is a blazing homophobe. And that she's like, wait a minute. There's something wrong with Uncle Bobby.
My favorite uncle is gay.
My favorite uncle is gay. Like, she couldn't tell before. Come on. And that the entire plot of the book is Uncle Bobby indoctrinating her and brainwashing her into embracing same-sex marriage and accepting homosexuality. That is simply not what this book says. And what is astounding to me is that here is a justice who is tasked with reading incredibly complex statutes and constitutional provisions, and he lacks the reading comprehension of a kindergartner. And so I guess I have to, thank you, buy Uncle Bobby's Wedding, and you will see what I mean. And I have to wonder, Erwin, I'll kick it to you, but either he doesn't understand words, And that is a possibility.
And meaning.
Or, and this ties back to my Planned Parenthood case, when culture war issues get involved, these justices can't see straight, so to speak. It distorts their perception and their analysis. And so in Planned Parenthood, the case kind of involves abortion. Planned Parenthood sometimes gives abortion. That's not really what it's about, but because that's in the periphery, we're going to nuke the Medicaid statute and Section 1983 and take away people's rights. In this case, it involves LGBTQ people, it involves LGBTQ books. Like, we're going to butcher and misread these books and vastly expand the scope of the free exercise clause to give parents this new opt-out. And just one final point that I do want to add as a gay parent, think about the message that it sends to the kids of same-sex parents in those classrooms when the teacher wants to read Uncle Bobby's Wedding and half the kids stand up and walk out. Think about what message it sends when those kids learn that there is something so wrong with their parents, so fundamentally wrong with their families, that kids in their classroom cannot be exposed to families like theirs, that the mere existence of families like theirs is too disturbing and wrong for their peers to learn about. I think it is extraordinarily stigmatizing, and the fact that those kids and those families are erased from the court's opinion again shows how the majority gets tunnel vision when it takes on these issues.
So I'm going to turn to Erwin, but I'm just going to let people know I thought I would never say this out loud in front of other people. This is a place where I miss Justice Kennedy.
Yes.
Because he actually was very good.
Yes.
On the questions of intimacy and rights and same-sex coupling between Lawrence and Obergefell. So the sense is this is Justice Alito announcing there is a new sheriff in town. We saw it in 303 Creative as well, but there's a whole different framing of this. Erwin?
All justices, liberal and conservative, come to conclusions and then write the opinions that justify their conclusions. There's no such thing as neutral constitutional law. Yeah. It's about values. And so it's not that Justice Alito can't read. He started with a certain perspective with regard to issues of religion and gender identity and sexual orientation, and then wrote an opinion that followed it. It's no different than, in this case, Justice Sotomayor starting with a different view and coming to conclusions that are consistent with that. I think the underlying issue that unites Scrimetti and Mahmoud is one that arises all the time in constitutional law. Who should decide? Let's take Scrimetti as an example. Should it be for the Tennessee legislature to decide what's medically advisable with regard to treating transgender youth, or should it be left to the parents and their children? The majority says, leave this to the political process. Chief Justice Roberts says that explicitly in his majority opinion. The dissent says, because this involves discrimination based on sex and gender identity, it's the role of the courts to look at the evidence and to make the decision. Now, what's in sharp contrast is Mahmoud. The Montgomery County school system made decisions with regard to curriculum. Traditionally, the Supreme Court says we give great deference to school boards when it comes to making choices to curriculum. But here the Supreme Court says, no, we're not going to defer to the Montgomery County school system. If parents believe that exposure of their children to the material violates free exercise of religion, they have to have notice and the ability to opt out. So there isn't the deference to the political process in Mahmoud that there was in Scrimetti. And both cases raise really difficult issues of where's the stopping point? In Scrimetti, is there going to be any judicial protection for transgender individuals when you see that what the Trump administration is doing, or what you see in terms of now trying to talk about blocking transgender care for even adults? Will there be any protection under the Constitution? And on the other hand, when you get to Mahmoud, Justice Alito's opinion had no cabining principle. Any parent who objects to anything on religious grounds now has the right to opt their children out. So when it comes to teaching biology or science where there's evolution, parents say, exposing my children to that, I have the right to opt my children out. If it's an English class where they're studying Harry Potter or The Wizard of Oz and there's witchcraft, parents have the right to opt their children out. If there's images of how people are presented that's inconsistent with their religion, the right to opt their children out. Both of these cases raise really difficult issues in terms of what's going to happen in the future.
So I'm glad that you brought that up, Erwin, because so on the question of, especially in these culture war cases, do we does the court defer to the government, or does it not defer to the government, right? At least when it comes to sort of anti-discrimination and rights, a lot of this goes back to a 1938 case called Caroline Products, where the court dropped a footnote, and in that, another footnote, it looks like footnotes are becoming, right, so important here, but like a footnote and said, look, the text of the decision says most of the time we defer to the legislature, because if we don't defer to the legislature is going to be so busy, it's not going to be able to do its job. But there are times when we don't defer, and one of those times, well, when rights are at stake and when there are discrete and insular minorities who can't protect themselves in the legislative process, right, for whom sort of legislatures could pass laws against their interests. Then we, the judiciary, have to step in and protect people who are politically unpopular, who are not agents in the political process, right? So in Skermeti, right, by deferring to the legislature, the court implicitly, if not explicitly, was saying trans minors don't need protection in the legislative process, right? They're not the kind of discrete, and they actually say this, they're not the kind of discrete and insular minorities who need our protection. But in Mahmoud, they slip it in, Alito slips it in, he says, look, these children, their interests are not protected. Something, I can't remember the exact line, something to the effect that children's interests in schools, right, are not protected legislatively. We cannot trust legislators to protect their interests. That's a Caroline Products move, right? So it's very interesting the way in which this idea of legislative deferral or judicial defer to legislatures or not is getting worked in different ways in these cases with respect to children.
So I do want to ask a question about some form of agreement or harmony on the court, right? So we at least had 4 or 5 cases this term where there were 9-0 unanimous opinions. The TikTok case, right, was a 9-0 per curiam. The Smith and Wesson, the Mexico government wanting to sue U.S. gun makers. Ames versus Ohio Department of Youth Services, which is about what you have to prove if you're a majority member for an anti-discrimination suit. Barnes versus Felix, which is that, the moment of threat doctrine, and what you consider in the totalities of the circumstances for a police shooting. Do those cases tell us anything about the places on where justices either have some sort of shared values or shared, interpretation about either their own role or the doctrine, or is it just in any set of cases you will find a handful under which, for various reasons, they can come to some sort of agreement? Because it wasn't all a 6-3 term. Yeah, Erwin?
There are always a certain number of decisions that I'd refer to as error correction cases.
Okay.
The lower court got it wrong, and the Supreme Court's going to step in and say so. Take the Ames case that you mentioned. The Sixth Circuit implied that a person who was from a majority, in that instance, sexual orientation, would have a higher burden to bring an employment discrimination suit than somebody who was gay. And I think it was predictable that the Supreme Court would say, as it did in Justice Jackson's opinion, no, the same burden for employment discrimination exists whether you're in the majority or the minority. Or your example of Barnes versus Felix. The United States Court of Appeals for the Fifth Circuit said, when there's excess of police force, focus only on the moment it happens. Don't look at the surrounding circumstances. That's absurd in deciding whether or not the officer acted reasonably. The Supreme Court corrected the error in that easy case. I think the fact that the Supreme Court has about 40% of the docket where it's unanimous doesn't tell us very much about the court, because those aren't the hard cases. Those aren't the ideologically divided cases. I think that to really understand the current court or any court, you have to focus on the other cases.
I'd just like to add, though, that I was heartened that 9 justices agreed that you are entitled to due process of law before you are deported.
But then didn't do anything to give them a measure of due process after the fact. Unless I'm wrong, you can correct me.
It feels like the bar is on the floor when we're trying to come up with something nice to say, and it's that immigrants get due process. And then, as I think you're implying, Mario, just not long after the court said that immigrants get due process in deportation proceedings, said that once they've been rendered deportable, they can be sent off, expelled to third countries like South Sudan that they've never stepped foot in, where they might face torture and death without any further due process. And so the court giveth and then taketh a lot away. But I want to just focus on some of the cases you just mentioned, because I do think those are areas where the Supreme Court's liberals do their best work. Because almost all of the cases you mentioned, those were actually majority opinions by liberal justices. And part of what's going on there is that the liberal justices have to do something other than simply dissent all the time. They have to write majority opinions from time to time. The court tries to distribute the cases fairly evenly. And so cases like Ames go to Justice Jackson. And she used that decision not only to do the error correction, but to pretty emphatically reaffirm that Title VII of the Civil Rights Act does protect gay employees. Yes, in this case, it involved a straight employee who claimed that a cabal of evil gays at her workplace was out to get her. Yes, it's kind of weird that the Supreme Court had to rule in her favor in a unanimous opinion, but Justice Jackson was able to take advantage of the opportunity in that case to say, but by the way, just as it protects straight people, it also protects gay people. In another case, Catholic Charities versus Wisconsin, this was about whether certain charitable organizations get a tax exemption for their charitable doings, even if they aren't proselytizing to the people who receive their services. And the Supreme Court said yes, and Justice Sotomayor wrote that opinion, and she used the opportunity to try to revive the Establishment Clause of the First Amendment, which protects the separation of church and state, which has been under relentless assault from the conservative majority for years now. But Justice Sotomayor rooted the decision very much in the idea that discriminating against certain religions based on their practices and favoring others violates separation of church and state. We have to treat all religions equally. We can't give any special favors. And so I think it shows like the liberal justices are thinking strategically in these small fish cases about how they can try to develop the law and press the law in a direction that they like, that they favor. The problem is that there's only so much they can do, because when a big case comes along down the road where the conservative majority wants to make a move, it makes the move immediately. When the conservative majority wants to take the Establishment Clause out of the First Amendment, it's just going to do it. It's not going to care that Justice Sotomayor wrote this wonderful opinion reiterating that the separation of church and state exists. They're just going to take it back out in the future. And I think I'm actually curious to hear what our co-panelists think about the role of the liberal justices right now, because it feels like a very difficult position to be in. When do you take advantage of a majority opinion to try to plant some seeds for liberal decisions or reaffirm liberal doctrines? When do you dissent in a really harsh tone that castigates the majority? When do you pull punches today? Because doing so could help you build future coalitions tomorrow. I think this is something that all three liberal justices are approaching in different ways. Justice Jackson is ready to burn the place down. God bless her. Justice Sotomayor is sort of like trying to make compromises sometimes, but standing her ground. And Justice Kagan is often signing on to what the conservatives are doing here. And I think all three approaches have their merits, but they all run into the problem that being in a three liberal justice minority sucks, to put it in legal terms, yes. And that each of them has extraordinarily limited power to move the court in any particular direction.
Anybody want to take up on his offer of saying how we think about the role of the liberal justices in this moment?
I very much agree that the three liberal justices see their role differently. I apologize, but I don't think Justice Jackson wants to burn the house down. I think Justice Jackson is writing for the press and the future, and very consciously doing so. I think she regards herself as having a very important voice, and she's going to articulate. I think it's completely appropriate for her or any justice to do so. That's why I thought the Adam Liptak article in the New York Times that said, well, Justice Breyer said it took him 3 years to get experience, and Justice Frankfurt, of course, Justice Brandeis saying it took him many years, which implies Justice Jackson shouldn't be speaking now. I think that's completely inappropriate, and I think she's very self-conscious of her role. I think so is Justice Sotomayor. And it's interesting, when Justice Ginsburg was on the court and she dissented, she believed that she should write the sole dissent and that the other dissenting justices shouldn't write separately. So if you look at cases like Shelby County versus Holder, Justice Ginsburg writes a very powerful dissent and there's no other dissents. I think Justice Sotomayor would like that role, and she writes so many of the prominent dissents. I don't think Justice Jackson agrees with that approach. I think Justice Kagan, though, does. Justice Kagan hasn't written the same kind of powerful dissents this term as Justices Sotomayor and Jackson. She wrote a dissent in Free Speech Coalition versus Paxton, a case about requiring age verification for minors having access to websites, but it wasn't the kind of dissents we saw from Sotomayor and Jackson. I think there's another thing that I think Kagan sees her role differently. I think she's much more trying to be in a conciliatory role. There are more cases where it's 7-2. Last week when the Supreme Court again said that the Trump administration could send people to South Sudan, Kagan joined with the conservative justices. It was Sotomayor and Jackson who were dissenting. So I think they see their role differently, but it's easy, and I agree very much with you, to understand how difficult it is. They care deeply about these issues, as do the conservatives, and it's really hard on the issues you care a lot about to constantly be on the losing side.
So I want to ask a specific question and then open it up for your final thoughts in terms of what we might expect moving forward into the fall term. So the specific question is there are a number of cases on the docket already, the shadow docket, for which if the federal government is denied its way, there are questions as to whether it will observe the rule of law and comply substantially. And my students, I'm teaching undergrads this summer. My students said to me, well, what is the mechanism we use to ensure that the president complies with federal, judges? And I didn't want to say, but, voluntariness. And your oath of office and the faith and fidelity you have for the rule of law. And so my real question is, Justice Roberts seems to be fretting mightily for the day when there will be a constitutional crisis around a disavowal or a refusal for the current administration to comply with the Supreme Court order. And I wonder whether we think we are on the precipice of that moment. And then more generally, if not that question, what do we think about the upcoming term in terms of either the shadow docket or at least I know you've already told us, Jessica, about 2 more trans rights cases are on the horizon. So how about, Courtney, we can start with you if you want.
Let's see. I mean,
you don't have an answer for my student either.
Yeah, I don't know if I have an answer for your student. I mean, yeah. Can you come back to me?
Sure.
I'll just say briefly, I think that John Roberts is playing an incredibly dangerous game that he's going to lose. Okay, let's just be clear. This administration has repeatedly violated district court orders already. That is not in dispute. That is a fact. This administration has deported people, put people on planes, impounded funding and appropriations in direct violation of federal court orders over and over again. And in multiple cases, the Supreme Court has rewarded it for doing so. In multiple cases, the Supreme Court has given relief to the Trump administration from district court orders that the administration had defied, had flouted. That was true most recently in the South Sudan case, where a judge said, don't put people on a plane to South Sudan, this is an order, and the administration put people on a plane to South Sudan, and the Supreme Court said, that's fine, send them off, no problem. And I think that John Roberts and Justice Barrett and Justice Kavanaugh, they think that they can throw these district courts under the bus, but that the administration will still respect their court when they want to draw the line. And that is something that the president himself has said repeatedly in interviews, that he doesn't really respect district courts or lower courts, but that he'll respect the Supreme Court. And I simply do not believe that when the time comes, and it will come in my view, that the Supreme Court says no to Trump, and he doesn't want to stop doing what the court has told him to stop doing, when that moment comes, and it'll be sooner rather than later, right? We're not even 6 months in, folks. We've got a long time to go. We are barreling quickly toward this crisis. When that time comes, Now that the Supreme Court has over and over again blessed the administration for violating court orders, what in the world is going to make Trump think differently about the Supreme Court? And I think the answer is nothing. And so I think that the Supreme Court thinks that it can endlessly sap the power of the lower courts without sacrificing its own authority. And I think that it will learn soon enough that it is badly mistaken and that it is giving Trump permission to treat it as just another layer of bureaucracy that Trump can blast through when it stands in his way.
Erwin?
I think the record of the Trump administration complying or disobeying court orders is a little bit more complicated than that. I argued a case in federal district court in Northern District of California in San Francisco on June 20th. It's a class action suit on behalf of all of the faculty and researchers in the University of California who had their funding cut off. The judge, Rita Lind, 3 days later, on Monday, June 23rd, ruled in favor of the class and ordered that the money be restored. And by our count, over $100 million of grants have been restored since the judge issued the order. I don't know what will happen on appeal. I don't know that all the grants will be restored, but certainly some have been restored. With regard to Trump versus ARP, the Supreme Court said no additional people can be taken to El Salvador until further court order, and the Trump administration has complied with that. There are also, as you say rightly, many instances of the Trump administration disobeying court orders, and the rhetoric is inconsistent. There are times when the rhetoric has been, we're not going to pay attention. Remember Donald Trump put out, he who saves the country violates no law. There's a direct quote. J.D. Vance has said on many occasions the president doesn't have to follow court orders. But there are also instances where President Trump has said he will comply with Supreme Court orders. I agree with your student's question, because ultimately, if the government wants to disobey court orders, there's almost nothing that can be done about it. In terms of criminal contempt, the president can pardon for criminal contempt. In terms of civil contempt, well, the United States Marshals enforce civil contempt, and they're under control of the Justice Department. And if we get to the point, and you might be right that we will, that the president can ignore the Constitution and then ignore court orders, then no longer are we a democracy under the rule of law. Because then the president can do literally anything. Send me or you or any of you to El Salvador, and no court would have any authority. No, none of us do. But then we are no longer a democracy under the rule of law. And the fact that we're talking about it should be of concern, but I don't think we can know at this point where it's going to end up.
So, well, Courtney and then Jessica will be the last.
I just want to add quickly, I feel like with the third country deportation stuff, they don't have to, right? The Trump administration doesn't have to disobey a court order because they've already achieved their purpose. Right? Like that, it's so performative. Like so much of this is so performative that we already got what we wanted. Right? Don't come here illegally because otherwise you're going to be going to Libya. Done. Right? Like we've already had it happen. It happened. Right? Like I almost feel like it kind of like push right up against a constitutional crisis, but then we don't need that to happen because we've already achieved the result we wanted to achieve. Yeah.
Great point.
So we're coming to the end of time. So Jessica, you get to take us out with your views on either this question or the next term.
So I agree with these last two comments in particular. A lot of what the administration is doing is political theater.
Yeah.
They've achieved a lot of their purposes. I think the dissenting justices, Sotomayor and Jackson, are trying to send us a political message. The court, it's been said, is the least dangerous branch. It doesn't have armies. It doesn't have funding to pursue priorities. John Roberts has said that the justice he admires the most was the first Chief Justice, who made the Supreme Court what it is, who took it out of the basement of the Capitol building and made it a third branch of government with equal status, despite not having the kinds of resources of the other branches. And he's going to do everything he can to protect that institution and its power, even if that means backing down to the Trump administration. So that means if you don't like what the Trump administration is doing, you cannot rely on the Supreme Court to stop them. You have to organize, you have to vote.
Wow. Well, on that note, join me in thanking one more time this amazing panel for this very stimulating conversation. Yeah, that was wonderful. And we'll see you for 16. I think I'm retiring, though. I think my hopefulness is in low supply at this point. So next year I will be in the audience enjoying the.
If you're not in South Sudan.
If I'm not. Thank you. Thank you so much, everyone. I'm going to take a picture.